All right, well, welcome everybody. I'm attorney Justin Randall with Hooper Law Office. And our topic today is on something called the Secure Act, which is a law regarding qualified retirement accounts like IRAs, 401ks, 403bs, all of those types of retirement accounts. So I'll just kind of collectively refer to them as retirement accounts going forward to save myself some time. But this law passed in it passed at the end of 2019 and came into effect in early 2020. And there's a lot of ways that it's really impacted people's plans for passing on their estate to the next generation, as well as the actual retirement planning side of it too. But primarily what I'm going to focus on today is how that really impacts the next generation and what you can possibly do to plan for that or to minimize the impact it'll have on the next generation. So before I get into details on that, though, just a couple quick reminders. This is meant to be interactive, so I'll see questions come up if you type them into the Q&A box. So if you have anything that comes up in relation to what we're talking about, absolutely, please feel free to do that. Send that in. And then at the end of this webinar, you'll get an email with our chart related to the rules before and after the Secure Act. It's very, very straightforward. Just really gives you kind of the overview of what really changed in terms of what's going to impact most people. I mean, it obviously changed a lot of things, but these are the most common concerns people would have, or the most common things people need to now plan around. And we do these webinars once a week, every Wednesday, same time. And our topic next week is on common Medicaid planning myths. And so that's a really useful webinar to watch, if you are interested or have any family members who may need to go into long-term care anytime soon, and you're trying to figure out what's the best way to plan for that. And then we'll also send out at the end of this a feedback form, which if anything we talk about today raises concerns for you that you'd like to come in and talk to one of our attorneys, we do offer free complimentary initial consultations where they are not, nobody pays us anything during those meetings. It's meant for us to get to know you and your situation and really figure out what we would recommend after that. Those are scheduled for about 2 hours. So we really want to set aside time to really dive into detail and figure out what we can do for you. So if you have that concern or you have anything related to estate planning in general or the Secure Act that you want to talk about in relation to your estate plan, please feel free to schedule a time to talk with one of us. Okay, so as I sort of touched on earlier, the Secure Act was a law passed by Congress in late 2019 that changed the way or some of the rules around qualified retirement accounts and how those work, both a little bit during the lifetime of the person and then also how that's going to impact someone's estate plan or their beneficiaries on those accounts. So one of the big things that impacts you directly as the holder of that account is that that law increased the age for what's called a required minimum distribution. So previously that age was 70 and a half. And once you hit that age, you had to start taking out your minimum amount per year from that pre-tax account so that they would make sure that eventually those taxes were getting paid, right? So that used to be 70 and a half, and it's actually been increased to 72. And even going further than that, there's actually what they're calling the Secure Act 2.0, which is not yet in effect, but likely will be, that increases that age even further incrementally, potentially up to 75, but that is not currently law. That's just been passed by the House. So keep an eye out for that though, because those rules may be changing again in a very short period of time. But the other thing that it really changed for you is the age at which you can no longer make contributions to a qualified retirement account. You can actually now continue to make contributions to a qualified retirement account as long as it's earned income from a job. So, a lot of people are retiring later than they used to. So it used to be after you hit 70 and a half, you could no longer put more money in. But now, even if you're taking required minimum distributions, you could, in theory, continue to contribute. because there is no maximum age anymore for that like contribution to a pre-tax account. So that was really the biggest change for the account holders, is that it changed a lot of the things. It was meant to fund it for a longer period of time, retirement, and make sure that people who are retiring later aren't necessarily being, forced to take out this income before they retire. Some of the impact of that, though, of course, is that because people are taking later required minimum distributions than they were previously at an older age, right? Life expectancy for that person may not have really changed. There may be more in that pre-tax account for the next generation than there previously was, because they, aren't taking those out any sooner than they used to be. The other thing that it does too is because that account can continue to grow pre-tax, I should say, before those required minimum distributions are taken out, is that as your life expectancy table hasn't changed, but you take those distributions out at an older age now, that could be, more tax for you because you're taking it out at a larger chunk than you were previously. So for some individuals, they may still decide to do some tax planning, and whether that's Roth conversions or just taking earlier distributions than are otherwise required, so that they look ahead and do a little bit of tax planning for themselves and make sure that they're not just putting off that tax while that account continues to grow. But from our perspective as estate planning attorneys, what really changed is how those accounts are dealt with for beneficiaries. So it used to be that, spouses, for example, could inherit their other spouse's IRA or 401k, qualified retirement accounts in general, and roll it over into their own, meaning they then got to use their own life expectancy to draw that down, and they didn't have to worry about taking it if they were prior to the required minimum distribution age, all of that. And that's still the case, even with that law change, for spouses. But what changed is that other beneficiaries under the old rules could also use their life expectancy or the life expectancy of the deceased individual, depending on which of those two was actually larger than the other. So if you were actually older than the person that you inherited the IRA from under the old laws, you could still use their life expectancy. But primarily, most people were children inheriting it from their parents, and they got to use their life expectancy, but had to start taking those required minimum distributions right away. So, I'm 29. So under the old rules, I don't remember the life expectancy tables off the top of my head, but under the old rules, it'd be somewhere in the neighborhood of like 50 years of being able to draw it down under the old rules. But I would have to start today if I inherited under those old rules. What really changed is that, except for a few pretty narrow exceptions, most people have no more than 10 years to take out that account now. And if it's, whether it's pre-tax, a traditional IRA, or a Roth account, that 10-year rule is the max that most people are going to have. There are exceptions to that 10-year rule, but they're definitely not going to apply to the vast majority of the population. One of those exceptions, again, is that the inheriting spouse can still roll it over as their own. That part has not changed. But whereas under the old rules, someone my age would have decades to take it out, I now have no more than 10 years if my parents were to pass today to take that account out. So what's a little unclear currently, because the IRS has issued new guidance on this, but was not what was understood to be the guidance previously, is that whether or not that 10 years means 1/10 every year, or whether it means just by the end of year 10 that has to be taken out or liquidated entirely. So we previously thought, based off of the prior guidance, that it was actually at the end of year 10 is when that account had to be liquidated. And now they've issued new guidance on it that says it's meant to be required minimum distributions based off of life expectancy for those 10 years. And then it has to be liquidated by the end of year 10. So the sort of silly thing about that is, if you're doing tax planning, you're probably taking out more than the required minimum distribution during those 10 years anyway, because of the fact that life expectancy amount for that RMD was actually lower than 1/10 for most individuals. So The impact is not huge on that, but it's still not what was previously understood to be the case. So for most people, if it's a pre-tax account, they're probably going to be stretching it out over those 10 years, taking out different amounts every year, potentially depending on their current tax bracket, to get the least in tax consequences that they possibly can. But some of the exceptions to that 10-year payout would be, I mentioned the surviving spouse, for example. Another would be if somebody leaves it to their minor child. So they get a life expectancy stretch up until the age of majority, so 18. And then they have that 10-year period after that. So really, somebody would be 28 by the time that account would be fully liquidated. But it does have to be a minor child of the original account holder. It can't be like just a minor in general. So a grandparent leaving it to a minor does not qualify for that purpose. It does have to be a minor child of the original owner. So this is one of those situations where that's going to be a very niche situation where somebody may actually qualify for that. Great that it is an option, but it's for most people, especially as they're aging and in retirement, this is not going to be a tax planning tool for a lot of people. One of the other stretches, exceptions to that 10-year stretch would be, for example, if somebody has a disability or, some sort of chronically ill individual, according to the IRS definitions of those words. So if somebody is unable to work due to a disability, they are chronically ill, they could potentially receive a life expectancy stretch, assuming they meet that definition of what the IRS or how the IRS has defined it. Then they get a life expectancy stretch because of those situations. But again, this is not going to be, at least I certainly hope not, going to be the case for most people, because you're only going to meet these circumstances or these situations if you do have a disability or if you do have some sort of chronic illness, and you're meeting these definitions very specifically. But then really the last and kind of the weirdest exception to that 10-year rule is if the beneficiary that's inheriting this IRA or 401k is not more than 10 years younger than the person who originally owned that account. So when we're looking at this, maybe a sibling passing it to another sibling and they're within 5 years of age, that may be a situation where that's actually, if you have a brother and a kid inheriting, it may be more beneficial, depending on how you want to split that estate, for some of that money to go to the sibling as opposed to the child, if that's the goal of the person doing the estate plan. They get a longer tax stretch. They get they get their life expectancy. And what's a little unclear about this, although I would assume that this is the case based off of the guidance I've seen, that whether someone is not more than 10 years younger than an individual, does that also include older individuals than the person who's leaving that account? And that would generally be yes, based off of everything I've seen. So there are exceptions to these 10-year rules, but for the vast majority of people, we are going to be stuck with that 10-year stretch if you're inheriting that IRA or 401k from a loved one. And why this is a concern, of course, is that especially with pre-tax money, the shorter period of time you have to take it out, the more you have to take out at any given time, meaning higher taxes, higher tax brackets on that than you may otherwise be in. And the other concern with this is that these people inheriting these IRAs tend to be when parents pass away, their kids tend to be, based off of averages these days, somewhere in their 50s, 60s, right? Either getting close to retirement or, in their prime earning years where they're just making that final push to retirement. And having a large amount of taxable money come to that person while they're in that situation of being in the highest tax bracket they may be in going forward just means that they may have to pay more in tax on that money than you did in retirement, because generally in retirement, people tend to be in lower tax brackets than they were when they were working, although there are, of course, exceptions to that. But so the issue we're running into right now is, how do we make this the most tax efficient thing that somebody can inherit, or how do we do tax planning for this to minimize that impact of that 10-year rule? Because we don't necessarily want someone in their prime earning years suddenly subject to a much larger sum of taxes. And this is, whether or not this is a big concern for somebody is of course going to depend a lot on what that person's current tax bracket actually is. And this is why it's really important to talk with your potential beneficiaries and see, hey, I'm thinking of doing this type of planning, and I'd like to do this in the most efficient way for you as possible. Knowing your kids' tax brackets, or roughly knowing them, is really helpful to make that decision, so that you can decide, if you have two people inheriting equally, maybe one person gets that amount in IRA money versus in just a mutual fund, right? Something like that might be the planning that somebody would engage in. So before I go into how do we deal with that, how are we planning around those sorts of concerns of not having a big tax implication because of the 10-year payout? One other big change was that so there were early withdrawals. So it used to be that you couldn't start taking money from your IRA or 401k prior to age 59 and a half without a penalty on it. But now there are some penalty-free withdrawals. If there's a pre-tax IRA that someone's doing this from, they still have to pay the tax on it, but they don't have to pay the the penalty on it that they otherwise would. Those qualified withdrawals are a birth or adoption of a child. You can take out a maximum of $5,000 per child. So every time a child is born, they could keep taking $5,000 out of their 401k tax-free, or not tax-free, excuse me, penalty-free per child. And then there is also an exception now for student loan payments, but only for a maximum of $10,000 for the lifetime of the entire individual. So, I can't take out $10,000 per year to do that, which would sure be nice, but can't do that. It's $10,000 maximum. Now that's a really good possible tool for people who, are trying to make that final push, maybe to pay off their student loans and don't have enough cash on hand themselves to do it. Can be helpful for that. For the doctors and lawyers or grad school students with a lot of debt because of it, it's maybe not going to make as big of a dent. But how we're dealing with this tax implication for the beneficiaries is encouraging people to look at planning earlier for the tax side of things than they maybe otherwise would. A very common issue we run into is partially because of Roths coming into the sort of mainstream a little bit later, or whatever the prevailing wisdom was back in the day. A lot of retirees right now have most, if not all, of their qualified retirement accounts in the pre-tax versions of those accounts. So traditional IRAs, 401ks, 403bs, right? Not the Roth versions of them. Well, there's some planning that they can do to potentially minimize the tax implications on their beneficiaries by looking at doing potential Roth conversions sooner than they maybe otherwise were thinking about doing it before they're taking their required minimum distributions. Working with a CPA on this and your financial planner is essential to make sure that this is efficient for you. It's a great tool for a lot of people, but it might not be for everybody. When you're doing this type of Roth conversion planning, it's not about moving it all at once. It's about looking at your tax brackets in any given year and what you'd have to pay in taxes, and moving an amount that makes sense for you at any given year, paying the tax on it from the traditional, converting it to a Roth version of that account. The benefit of that is, of course, you get to sort of do some tax planning on it and pick the tax bracket, or at least have some control over the tax bracket that you're paying that on, versus what your kids are going to have as their own tax brackets. And with that shorter period payout from the 10 years, the other benefit for you is the sooner you do this, not only can you do more of these Roth conversions during your lifetime, but you can also have that Roth account grow tax-free for the rest of your life too. And you never have to take required minimums out of a Roth. So not you don't if it's yours, your kids still do if they inherit it. But that is not always a good strategy for people if they themselves are in a much, much higher tax bracket than their kids are ever likely to be, or if they're spreading it out to a bunch of different people. And so each person's getting such a small amount that the tax benefits aren't really outweighing the tax cost. Or if you're really, really charitably inclined, it doesn't really matter how much you convert to Roth before you leave it to a charity. That charity is never going to pay tax on that qualified retirement account. So that's the kind of thing where it may not be the right fit for everybody, but you don't know until you talk to the professionals you work with. And although it's, we bring it up to our clients all the time as something, if they're not already doing, recommending addressing that potential option for their with their financial advisors and CPAs. It's really the CPAs and the financial advisors who are doing most of that analysis and most of the heavy lifting there. It's one of those things where I'm certainly not an expert on the analysis or the tax side of it in terms of what makes sense for that person in any given year versus their kids, but something that I highly encourage people to look into if it's that tax planning is something they're trying to do. You do have to be very careful with the new rules, in particular, depending on if you're having an IRA go potentially to like a trust fund for somebody, how that trust is set up, making sure that if it sees through to the individual beneficiaries, that there's only individuals that can inherit from it and not potential entities or non-individual beneficiaries, right? Because that 10-year payout can become a 5-year payout if it is not basically a person with a heartbeat who is inheriting that account. Obviously for charities, that's not a big concern, but if it goes to a trust fund for somebody and it's can hold all the funds in there, what's called an accumulation trust, then if there's a charitable beneficiary that is also potentially somebody that's going to inherit from that account later, from that trust later, it can force a 5-year payout for your beneficiaries initially too. Another place where this becomes a really big concern is when somebody leaves their IRA or 401k to their probate estate. If it is not going directly to the beneficiaries or to qualifying trusts for those beneficiaries, it can become a 5-year payout, even though it ultimately does only go to individuals. So unfortunately, I've had clients where they've come in and, after having dealt with a parent's estate that, they never had beneficiary designations on their IRAs, right? And it did happen to go through probate. They were stuck with that 5-year payout because it is not an individual that it's going to. It's first going to this sort of non-individual entity or the estate of that person. So the 10-year rule can actually become a 5-year rule if it's not planned for properly. So the only thing you need to really remember about that is that you're making sure that you work with professionals who are aware of what those rules are and can help you make sure that you're not violating the qualifications for that 10-year payout, because 10 years is already short enough to do any tax planning for people, but 5 is obviously even shorter. So making sure that those individuals have, the best stretch they possibly can is really essential because of the shorter period of time that we now have for those IRA distributions or 401k distributions after inheriting an IRA. Now, I should mention that if you inherited an IRA from a parent or a loved one prior to January 1st of 2020, so if it was during 2019 or earlier, right, you don't suddenly have a 10-year payout. You have the life expectancy stretch. They, grandfathered in the old ones or the old inherited IRAs. It's not suddenly that you now have 10 years. But that's really just a big warning for you, just to know that you don't suddenly have to panic if you have an older inherited account. It's not suddenly changed for you. So only if you inherited after January 1st or on January 1st of 2020 or later do you have to have that 10-year payout. So really, there's sort of two sides of that planning opportunity for you is if you're still working and you're able to contribute to a Roth, that's possibly a really great tool for you. The more you get in there, the sooner you get it in there, the larger that Roth account will be by the time you pass away. And your kids don't have to pay tax on the Roth. So the beneficiaries don't have to pay tax on a Roth either. So that's why those Roth conversions are so essential if you're trying to minimize the tax implication for that, the beneficiaries you're leaving those accounts to, because then, yeah, they still only have the 10 years to take it out potentially, but they're not also then bumping up their own tax brackets. We sort of joke that the worst sort of IRA situation would be, some sort of like surgeon with a multi-million-dollar IRA or 401k, and they have one child, and that child is also a surgeon in a high tax bracket. That's going to be the worst tax situation that you probably could be in for someone inheriting that account. Roth conversions are a really good way. You pay the tax on it, of course, when you're doing that, but if it makes sense for you to do that after talking with your CPA and your financial advisor, it can be a really good tool to at least minimize the tax implications on that account for your kids. So I'm not seeing any questions, but I will just have a couple last minute things to say here for you guys. Just a reminder too, that if you would like to come in and talk to one of us, that our consultations or initial consultations, are complimentary. They don't cost you anything to come in and talk to us. We can let you know at the end of the meeting, generally speaking, or after, if we need additional meetings, then that's fine too. But we can usually let you know what we would recommend for you and what that estimated cost would be if there's something we need to do. But those are scheduled for about 2 hours, so we can really get to know your family and the situation and give you the best recommendation possible. And again, our topic next week is actually on common Medicaid planning myths. So that's a really, really useful one for people if you are concerned about long-term care for yourself or for a loved one, and you really just want to get some information on maybe, whether or not the things you've heard are actually correct or not. There's unfortunately a lot of myths going around on the internet, or people rely on, other states' rules, and they vary state to state for Medicaid. So with that, I will wish you guys a good rest of your day, and I hope to see you next week.